now we'll be discussing about the other agreement involved in a M&A transaction, which would be the shareholders agreement. So as I had clarified earlier when we started this session, that a shareholders agreement just governs the rights and obligations of a shareholders of a company, and all sorts of rights, obligations, how a company would be operated. Uh, let's say the number of directors, quorum, etc. All that is documented in a shareholders agreement. Now, obviously, a shareholders agreement can be a very complex agreement, can run into a 100-page document also, but it depends on the on transaction to transaction. And I would try to restrict the discussion to the key provisions involved in which are captured in a shareholders agreement. Okay, because there are n number of permutations and combinations, and depending on that, a shareholders agreement can be drafted in n number of ways. Now, beginning with the first clause, which would be the effective date. So, let's say it's a 100% share acquisition. Not 100%. Let's say assume it's a 50% share acquisition, or let's say a new investor has come who has invested in a company, which will entitle it to have at least 50% stake in a company. So obviously, the acquirer will, in case it's a share acquisition, there would be a share purchase agreement. Okay, if it's a 50% share acquisition, or if it's a subscription, there will be a share subscription agreement. Obviously, on the same date wherein the share purchase agreement is executed, ideally a shareholders agreement will also be executed. Okay, the reason being is that obviously, let's say there were three shareholders in that company. Okay, and they had their own mechanism of governing their rights and obligation. Let's say there was an existing shareholders agreement, but now obviously with a new investor, new acquirer coming in, who's now holding 50% stake in the company, obviously now the investor or the acquirer would want to ensure that his or her rights or its rights are protected by, and ensure that at least whatever negotiations he has had with the other parties are all clearly documented in form of an agreement, so that going ahead there is clarity with respect to the specific rights obligations of each party or each shareholder in a company. Okay, so obviously, as on the execution date of the share purchase agreement, the parties would also execute a shareholders agreement. Okay, it's an ideal situation. As again I said, it totally depends on the transaction also. So on the same day they'll execute a shareholders agreement also, but the effective date of shareholders agreement or the key provisions of that shareholders agreement would be the closing date under the share purchase agreement. Okay, because the actual remittance or the transfer of shares is happening under the share purchase agreement on the closing date. Like, I'm just trying to draw a link. As I explained, the signing and the closing could be different because there could be certain preconditions or conditions precedent which have to be satisfied between signing and closing. So the date of effect, or the date on which the new shareholders agreement will come into place. He's using the word new shareholders agreement because the earlier shareholders may have had a shareholders agreement up till now. So now the current shareholders agreement, post the acquisition of majority stake by the acquirer or a subscription of shares by the investor, will come into effect from the closing date under the share purchase agreement. Okay, so now this was the concept of effective date. Now coming to the other important part included in a shareholders agreement would be determining how the company will be run in relation to the meetings of the company, the directors of a company, because obviously if I'm acquiring 50% stake in the company by way of acquisition or by way of subscription, I would want my nominee director to be on the board of the company. So that will be clearly reflected in that specific part of the shareholders agreement. The heading could be the management of the company, wherein it will be clearly specified that the board will consist of so many directors nominated by this investor, so many directors nominated by the old investor, so on and so forth. Okay, it depends. It's a commercial call which has to be decided. It's a commercial point which has to be decided between the parties. But the composition of the board is something which is very, very important, and it is usually documented uh, in a shareholders agreement. Now again, and one more thing which I missed when I was discussing the share purchase agreement. Let's say uh, let's say I'm acquiring. I'm just giving an example. That let's say I'm acquiring 100% stake in the company. Then obviously there could be no requirement of a shareholders agreement because I have acquired the entire stake in a company. So there's no other party left to negotiate with, or there's no other party with whom I have to govern or discuss my rights and obligations. So then there's no requirement of a shareholders agreement. Okay, but uh, let's say there are two more shareholders left in the company, or let's say someone is stepping down as a director. Okay, let's say the promoter and another person, his brother was, or his wife was, let's say the director in a company, and now since I have invested in the company or acquired a majority stake, I want to, one person to step down. So stepping down of one or resignation of a specific director, that also has to be documented in the share purchase agreement itself. That on the closing date, XYZ person will submit his or her resignation, and because in the close in the SPA we even document the closing day actions, that what will happen on closing. Company obviously will do a lot of secretarial stuffs involving meetings of the board and the shareholders depending upon the nature of transaction. So all that forms part of the share purchase agreement. So that is interlinked. So the composition of board is something which has to be decided beforehand, and that has to be documented in the shareholders agreement itself, even though resignation may be taken care of in the share purchase agreement. So the composition, how many share, or which party is entitled to appoint how many directors, that is documented in the shareholders agreement. At the same time, even how the meeting will take place, how many directors will constitute a quorum, all that of in a board as well as in a shareholders meeting, that all that information is documented in a share purchase in a shareholders agreement. Okay, now after this point, which is dealing which dealt with the management of the company, which and I explained, and even sorry, I missed a point. Even uh, uh, all type of mechanism, or uh, how the reappointment of directors, or how the vacancy on the board will be filled, all that has to be taken care of in the shareholders agreement itself. And under the broad heading, again I'm saying the management of the company, and even though I'm using the word broad heading, that's just for clarity perspective. There's no hard and fast rule that you have to give only this heading to this specific clause. It totally depends on how you are drafting it. Okay, because there could be 5 ways of writing the same thing. Now another important part which I would want to discuss is the concept of veto matter list, or the AVM list, affirmative vote matters. Now this is very important. Now obviously this is something which someone who's interning or who has just started working may not be aware of, but in a shareholders agreement, ideally, like, I'll take a step back. Ideally there are a lot of matters pertaining to the governance of a company which are very important. Like let's say there are, obviously it's a very subjective term. What is important to you may not be important for me, because, and that's why this AVM list is always again a highly negotiated list. Lot of back and forth usually happens. But like for example, I'll just give a very simple example: appointment or removal of a KMP, key managerial personnel. This is something which is very crucial to a company, right? Or let's say uh, taking of loan taking of loan by the company exceeding 10 crore or 5 crore. I'm just giving a hypothetical number. This is something very important. So obviously an investor, or let's say if there are many investors, let's say there are 5 investors in a company, and some of them hold let's say 10% stake in a company. So even if a 10% stake investor, obviously he has invested in the company, he may or may not have a board right, but he has invested his time in the company. So he would want to have some bit of say over certain key uh, aspects of operations of a company. Okay, so these key essentials, or the key aspects of operations of a company, or key items, are known as affirmative vote matters. This is a very layman, in a very layman words I have explained. So basically, to put it in even simpler words, AVM matters is a list of matters with respect to which decision cannot be taken e- either at board level or at shareholder level unless and until the party, unless and until a specific party or parties has given consent. Okay, it's as simple as saying that, look, this is the list of matters. I am holding 10% stake in the company. As long as I have at least 8%, this is a fall away threshold. I'll come back to that later. I am an investor. There are 5 other investors like me. They may or may not have this right, but at least in relation to myself, I am just saying that, look, this is a list of matters. List of matters, I may just give an example. One matter would be appointment of KMP, removal of KMP, instituting a litigation against the company, taking loan exceeding 10 lakh or 10 crore, depending on the size of the company and how it's negotiated, or let's say removal of company secretary, or let's say appointment of an auditor, removal of an auditor. There could be innumerable matters in the AVM list, and it totally depends. It could be a short list also, it could be a long list consisting of 40 items also. So I would say that as long, or parties will agree, that as long as this XYZ party or parties holds at least XYZ stake in the company, no decision can be taken either at board level or at shareholder level without consent of this party or parties. As simple as that. To put it in very simple words, that these are important for the operation of a company, I must have a say, or these specific parties must have a say. Only and only if the consent of this or this specific party or this party has obtained, only then we can go ahead and do that matter, pass that matter, appoint a KMP, remove that KMP, appoint an auditor, remove that auditor, take a loan, okay, or pay off the loan. Okay, so this is the concept of AVM. Now I just use the concept or the word, the terminology fall away threshold. So fall away threshold is very simple. To put in very simple words, a lot of times these legal jargons sound very complex, but they are very simple. Okay, so fall away threshold basically means that I have this AVM right, absolute right of preventing passing of this matter only and only till the time I have X% of shareholding in the company. Okay, let's say I have 15% stake in the company, and it's documented in the SHA that you have this right of AVM right, that no matter on this AVM list will be passed unless your consent is taken. You have this that right only and only or till the time you hold let's say 8% stake in the company. It's again like it's a commercial thing, negotiated point. I'm just giving a hypothetical number, so any number which I'll take, it'll always be a hypothetical number. So till the time you have that 8%, you have that right. Fall away threshold will be that 8%. So this 8% is just a fall away threshold. If your shareholding falls below 8%, then your consent is not required for passing those matters. Okay. So till the time you have that threshold, no one can pass that matter, and if they do so, it'll be void. Okay, it'll be void. It'll have it won't have any authority. Okay. Similarly, fall away threshold, I gave an example. There could be a blanket fall away threshold also. Like for example, let's say there are 5 shareholders, and their shareholding is different. Like someone is holding 20%, someone is holding 50%, someone is holding 10%, someone is holding 8%, and they have appointed, let's say 3 of them have the right to appoint directors. So in relation to them also, there could be a fall away threshold, that till the time you have let's say 10% stake in the company, till the time you have 10% stake in the company, you can appoint a director. But as soon as that threshold, like basically your shareholding falls below that threshold, you lose that right to appoint the director. Okay. Or fall away threshold, I'm just giving numerous examples of fall away threshold. Or there could be a in the management of the company heading, there could be a paragraph stipulating that the quorum of the board will consist of 3 directors of like let's say it'll consist of so many directors, out of which uh, 3 directors should be of XYZ investor. Okay, so the threshold, basically the following threshold can even apply to such quorum requirement also, provided that ultimately when it comes to quorum, you have to comply with the applicable law, because there is a specific provision company, for a public company, the quorum has to be so and so. But let's say if you are documenting in your agreement that for a quorum requirement of at least 3 directors of this specific investor would be required, there could be a follow-away threshold also. There could be a general follow-away threshold that uh, for all the matters specified in, or all the rights specified in this agreement, the follow-away threshold for the investor 1, 2 or XYZ should be 5%, because there could be other rights also, like for example information rights. I'll be dealing with that concept later. So this was about management of the company, then about uh, affirmative vote matters. Now another aspect which I would want to deal with it would be anti-dilution right. Obviously anti-dilution is a very, it's not as simple as it may sound when I'm explaining, but at the same time I'll try to explain in a very layman uh, uh, method, so that who has no, like someone who has no understanding of this concept will get some understanding of what is an anti-dilution right. Basically anti-dilution right, to put it in very simple words, says that, like, let's say if I'm already an investor in the company, okay, and when I invested in the company, I got the shares at 1,000 rupees. I got one, like my like I got the shares per share. I had paid 1,000 rupees valuation. Okay, now let's say after 2 years, a new investor comes and he is getting the share at valuation of 500 rupees at a lesser price. So for the same amount of investment, he will get entitled to more number of shares. So I will get diluted to that extent. So the anti-dilution right entitles me to get so many shares from the company to ensure that my shareholding is not diluted in case the company issues shares to a new investor at a price less than the price at which I had come or invested in the company. Very simple, in very simple words I'm saying. Okay, so that is anti-dilution right, and these shares which will be issued will be, will not be at any consideration. Like you won't have to pay something extra for acquiring these shares. This will be just to maintain your shareholding. Okay, so this is the anti-dilution right. Now again another right which is documented usually in a shareholders agreement, which it would be preemption right. Preemption right basically means that if I am already a shareholder and if you issue shares to a new party, obviously I am holding a 10%, 20% stake in a company. If you issue shares to a new party, obviously now he will be holding certain stake and my shareholding will go down. It is just sounding complex. I'll give you a very simple example. Let's say let's say there is a uh, let's say I let's say there's a pizza. Okay, let's say there's a pizza, notional pizza. Just assume there's a notional pizza in front of you. Okay, and you have been let's say told that you also have some stake in it. Okay, you have stake worth 1/4 of the pizza. Okay, and you have been told 1/4 of the pizza you have been told. Okay, that is your stake. That is your, let's say, shareholding. Okay, and let's say someone is again coming on board, like let's say, and there are other people also entitled to that pizza. Okay, and let's say they are also sort of doing some value addition, pursuant to which they have also been promised certain stake in that pizza, that look, you are also entitled to this pizza, because along with pizza you have brought on board some other additional dish. Okay. So obviously, if they are also now you are not the only entitled person. There are 5 other entitled person to that specific pizza. Obviously, so your stake in that pizza, that 1/4 stake, let's say that 20% which was existing back then, that 20% is now has now got diluted, because that other person also has some stake in that pizza, because he has also done some value addition and brought on board some additional dish with him. Okay, so obviously, again, to give a simple example, that let's say you are holding 20% stake in a company, and there were other stakeholders also holding 30, like let's say 30% stake, 30 and 20. Okay, that will make it 100%. Okay, so 30, 30, 20, 20. Now a new investor infuses funds in the company. Okay, infuses funds in the company, right? As I was giving example of pizza, that pizza example, you must be thinking that, Array, I was promised 1/4 stake, so why would I bother if someone else is bringing something else? I am entitled to 1/4. I will eat that 1/4 stake. So that doesn't work that way. So this value addition, which I'm just relating, because taking that pizza example in isolation, someone may get confused, because that person may think that, Array, I was promised a 1/4 stake when I promised, like when I entered into that agreement, I was promised a 1/4 stake in the pizza, and I'm not bothered about someone doing anything. But look, that person is doing some value addition, infusing something. Similarly, that person is infusing funds in the company. Okay, and pursuant to that, in consideration of that infusion, he is entitled to certain stake, right? So if he is entitled to, let's say, 10%, so proportionately, obviously, the shareholding of all the shareholders will go down, right? If earlier it was 30%, 30, 20, and if there's a other person now who's infused funds, who has acquired this 10% stake in a company, then it can't be 30, 20, 110, it cannot be 110%, right? The percentage, the equity composition cannot be 110%, right? So he will hold 10% stake, and to make good of that 10%, your equity will get diluted proportionately to accommodate him, right? So obviously, so coming back to this concept of preemption, right? So obviously, if a new shareholder is coming, without doing anything, my shareholding may get diluted. So under preemption right, the existing shareholders get a right to subscribe to the shares. They get a right to subscribe to the shares, so that their pro rata shareholding, so that their shareholding is not diluted. Okay. Now there are other several clauses, like another important aspect to a shareholders agreement would be the share transfer provisions and the exit clauses. Because in share transfer provisions, there could be ROFO, ROFR, tag, drag. Like these are, for example, I'll try to explain in brief ROFO, ROFR, tag, drag. So if let's say ROFO is right of first offer, right of first refusal is ROFR, tag and drag I'll explain. So right of first offer, like let's say there are two shareholders A and B, okay, and A has granted a right of first offer to B. Then in case like let's say A has offered a right of first offer to B, in case A proposes to transfer his shares, he will have to first offer it to B for purchase. Okay, so only if B refuses, or only if A is able to find a buyer who is willing to pay a higher amount, only then he can transfer. Then right of first refusal would be, let's say if A and B are two shareholders, A has given a right of first refusal in favor of B, has granted the right of first refusal in favor of B. Then if A proposes to transfer his or her shares, then A will first have to find a third party buyer. That price he'll take to B. He'll tell B that, look, are you ready to willing to buy that price? If B is able to match that price or pay any higher, then B will have the right to purchase those shares. Only if B refuses, or is not able to match that price, only then you can sell. Similarly, tag and drag. Tag basically means that if you are selling, you will also sell my shares. Okay, you will tag me along with you. Okay, drag means that if I am selling, I'll drag you with along with me. You will also be entitled. You will also be required to sell the shares with me. Okay. Similarly, exit clauses, put and call option, or like these there could be exit clauses like IPO and third party sale, buyback also. Third party sale would mean that you will find a buyer for my sale. Then initial public offering, something which it's very easy to understand. The name suggests, the name itself suggests what it is. Then buyback would be the company will buy back the shares from me. Call put option basically means, sorry, I'm hurrying because we are in uh, extreme paucity of time. Call put option mean that call option basically means that I have the right to purchase your shares at a within a stipulated time period at predetermined price. Put option means that I have the right to sell my shares within a stipulated point of time at a predetermined price. So these are the key provisions pertaining to a share purchase agreement. Obviously, there could be numerable clauses, but I have tried my best to at least understand or explain in a very brief manner, so that someone who doesn't have any understanding of both these agreements, share purchase and shareholders agreement, that person will get some clarity, so that once he starts working or reading these agreements, he'll be able to relate it. Thank you. Hope this session was useful.